Welcome, and thanks for joining today's session, ProbateCash, Facts and Fiction, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. The presenters will address questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after the presentation. Our presenters today are professionals with extensive experience in all aspects of providing cash advances to individuals awaiting inheritance payouts. Mark Harris has been working in the specialty finance industry for 25 years, involved in purchasing of over $100 million of assets. Most of the purchases, pursuant to various state laws, required court hearings, many of which Mark has either attended or has appeared as counsel. As a result, Mark has the advantage of meeting customers, their lawyers, and establishing relationships to find collaborative solutions for their customers. Mark has spoken at numerous conferences and has been active in working to draft model legislation adopted by many states in the country. Mark earned his undergraduate degree from Florida State University and law degree from Nova Southeastern University in Fort Lauderdale. Mark is very active in his community and is an officer on an advisory board for a nonprofit organization. Mark, his wife, and 2 children reside in Parkland, Florida. Today, he's here to speak about the relatively new business of purchasing interest in actively pending inheritance claims.
What were your initial thoughts when you heard about advances on inheritances?
Buddy, thank you for attending. Good afternoon or good morning, depending on where you are in the country. Myself, not having a trust and estates background, I thought, first, can you even do this? And second, would people need that service? Even as a lawyer who's also married to a lawyer, I didn't appreciate how long and complicated the probate process often was. My background is focused on providing upfront cash to people who couldn't wait for payment streams due to them in the future. In that respect, inheritance funding fits that description perfectly, providing upfront money to heirs today who cannot wait for the probate process to conclude.
Assuming everything goes well and as planned with the probate process, how does the personal representative know how much money to send ProbateCash from their heirs' inheritance?
One of the key features of these transactions is their simplicity and clarity. Before anyone signs anything, they know what they will be getting in upfront cash and what they will be giving up later when the estate eventually settles. Once we enter into a contract with an heir, we file that assignment within the probate case. Our court filing outlines the assignment from the heir to our company, and specifically how much money from the heir's share of any inheritance the personal representative must pay us at the time of the estate's final distribution.
One question I'm seeing a lot of is, how much do you charge?
That's a reasonable question. Now, of course, I cannot quote a one-size-fits-all price. We tailor each transaction to the specific facts of each estate. Some of it relates to the complexity of the situation. An estate that is all cash and is near closing is going to have lower fees than an estate with a dozen properties, feuding heirs, and an array of third-party creditors. Also, dollar amounts matter. Someone needing $5,000 is going to get a different kind of pricing than someone trying to raise $500,000. And someone that is just a month away from distribution is going to get priced differently than an heir who may be 2 or 3 years away from getting any money. Both happy to have more specific pricing with heirs, their professional representatives, administrators, or lawyers representing the estate. I will say this, if we can have open communication with an attorney handling an estate, that can only help the estate and the heir get a better deal. Often, an heir we speak to will be uncertain about the exact status of the proceeding of the probate or the sale of properties. If there is such uncertainty about what's going on or who's going to get what in an estate and when, a cash advance provider will respond to that uncertainty by wanting to advance less and charge more to compensate for that risk. Therefore, I always welcome estate attorneys to call me so we can better understand the actual situation. Simply stated, the more we know, the better we can do. So the fees vary specific to the heirs and the estates.
Okay, great. It looks like we have another question from Mark. Can the advance be repaid before the estate's assets are distributed?
Sure, absolutely. And there is no prepayment fee. As I said, our transactions are absolutely transparent and clear. So that can be done. And in some of those cases, the amount repaid will, according to the terms of the transaction, probably be even less money.
Okay, great. And it looks like we actually are going to be heading out of time before we know it.
Let me make sure you get Mark's information. You can email Mark
At mark@probatecash.com, and that is Mark with a C, not a K, or at 561-476-0018. And again, we just want to thank everyone for joining us and just have a great day. Thank you so much.